Good morning, everyone. Thank you for this opportunity to provide some information about the publication ban. I want to emphasize that the information that I'm giving you today is about the current publication ban in place, and it's about protecting the identity of children and youth receiving services. So in order to do that, what I want to do is cover three areas. One of those is, why is there a publication ban? Secondly, what does the publication ban currently cover? And thirdly, are there any exceptions to the publication ban? In doing this, it's my hope that I can provide some clarity about what information can be published, and also clearly identify what currently, or which information currently cannot be published. Before I talk about that, I think it's important that I provide some context that this needs to be considered in. So as a parent, and I imagine all of you, whether you're a parent, an aunt, an uncle, grandparent, we all have an expectation that when we reach out to access services, whether that's medical or mental health or any kind of treatment services, that the information that we provide and that's gathered, that we're asked about, that information is protected and only shared with those people that need to know in order to provide us care to meet our needs. So that's the context. Now I want to talk about why is there a publication ban? We are talking about weighing out the balance of the privacy of children, youth, and families with our responsibility as a ministry to be open and accountable about the work that we do and how we do it. And it's that balance today, and I appreciate the process and the question and the fishbowl approach, the discussion. It's that balance that we're talking about. To help ensure the privacy of children, youth, and their parents, the Child, Youth, and Family Enhancement Act prohibits the publication of specific identifying information in a way that reveals that the child or youth is involved with the child intervention system. It is crucial to protect the privacy of these children, youth, and their parents so that they can receive the supports and services that they need without intrusion or stigmatization. We've heard about and we've talked about families are often in very difficult situations. They may be in crisis. They may be seeking out help. They need to be reassured and know that they can get help without information being made public. I want to talk about what the current legislation identifies as being not able to be published. So the legislation is clear right now that what can't be published is the name and or photograph of the child or the child's parent or guardian who are receiving services. So the key thing there is that it's about not publishing a name or a picture that would identify them as receiving services from child intervention. So this is about the legislation. The intent is to ensure that children and youth are protected if they're receiving services, whether they're in care, whether they're receiving services at home. I want to add a point that I think is crucial that we're all aware of. There is provision in the legislation for interested parties, such as the media, to apply to the court for permission to publish protected information on the basis that that publication is in the child's best interest or the public best interest. In 2007, the court identified, when this matter was before the court, the public has a right to be informed of issues concerning the care of children in need of intervention. But this objective must be accomplished without releasing information that serves to identify a given child or his or her guardian. The presiding judge talked about, or that perspective is that it's not to limit parents from discussing their situations. So it doesn't prevent a family, a parent, to talk with the media about their circumstances and for that information to be published. But as the court ruling, what the publication ban is clear about is that information, a name, a photograph, cannot be shared in a manner that would reveal that they're receiving child intervention services. The other thing that I want to talk about is, are there any exceptions to the publication ban? And there are circumstances in which the name or photograph of a child or a youth can be published. One of those is in my area and my responsibility as statutory director of the Child, Youth and Family Enhancement Act. If I have reason to believe it's in the best interest of the child or necessary for the proper administration of justice, I have to weigh out whether or not to consent to that publication of the name and photograph. We're going to hear from some youth. That's one of the other exceptions. A youth that is 16 years of age or older can consent to the publication of his or her information. And as I've described, the court can grant permission to publish the name or photograph of the child or a parent. I want to give you an example of times when we do provide consent to release the name and a photograph of a child or youth. And it's done on the premise that we're not identifying that they're receiving services from child intervention. It's one of those circumstances is a situation where if a youth is missing and we work with the police to try and locate that youth, we can and we do publish the name and picture of that youth. What we won't do is we won't say, and we can't say, that that youth is from this group home or this foster home. The other one that I mentioned already is youth over 16. They can consent to their name and photograph being published. And I think what I appreciate is, as we move forward in the roundtable discussion and focus on that balance of protection of privacy and being open and accountable, we have some youth that I met that are here and will be part of the discussion. Thank you.